right away, there's immediate concern, right? It can be very daunting depending on the nature of the claim. And your immediate concern is, I need to get the right lawyer in place to defend myself and protect against maybe a reputational concerns, maybe it's a huge liability concern, right? It could be a bet the company type litigation. So this can be, a very serious issue. And we wanted to talk to you about it today because I think a lot of people sometimes overlook the importance of the defense cost coverage and all the, particular nuanced rules that go along with it. You may have heard the duty to defend is broader than the duty to indemnify, and that is absolutely true, and courts universally recognize that. But in New Jersey in particular, there are some fairly nuanced rules, so you should all be aware of those. We have somewhat of an ambitious agenda. You can see here everything from trigger to, the difference between duty to defend and duty to reimburse. We'll get into some allocation issues, independent counsel issues. It's somewhat ambitious. We'll try to get through as much of it as we can today.
So to start, why should we all care, right? So the typical headline of an exciting litigation is the 7, 8, 9, 10 figure judgment at the end of the case, right? For the policyholder, a lot of that story comes before that final judgment. That's particularly true in the instances of mass torts, which is a good example to show the importance of the duty to defend. So, for example, 3M and its subsidiary started facing lawsuits with the Combat Arms earplugs. They went through a multi-district litigation. They went through a big Chapter 11. At the end of that story, you would hope as the policyholder, right? You've gone through this long journey. You're at the final judgment, and the story's done. It's not. In that case, there was a post-judgment coverage litigation with 3M, its subsidiary, and their insurance company that was litigated all the way up to the Delaware Supreme Court over about $370 million in defense costs. In the asbestos cases, we see a 1978 report by the Rand Institute that aggregated most asbestos claims up until that point, and they found that there was about $60,000 of judgment costs. For every $60,000, there was $35,000 of defense costs. That's about a little bit over a third. 40 years later, with talcum powder, Vanderbilt Minerals earlier this year, files Chapter 11. Their initial reports from their chief restructuring officer indicate that they filed Chapter 11 because they faced over $120 million in top lawsuits. They had spent $50 million defending those claims, $8 million in that previous year up to the filing. You see the correlation. We're talking about a 1978 report. You jump 40 years later, Vanderbilt Minerals files Chapter 11. It's 40% of the total exposure a policyholder is going to face is being comprised of defense costs.
So when we talk about defense cost coverage, what types of policies should we be looking to? It's essentially any type of policy that provides coverage for third-party liabilities will typically have some form of defense costs. Now, the way they handle those defense costs will be different, right? So you have your CGL umbrella excess bucket. Typically in those policies, your defense costs will be outside of limits. You'll have a small deductible. The insurance company will likely control the defense and appoint their panel counsel. We'll get into when they can't do that. And then you have your other sort of financial products, your D&O, your E&O, your EPLI, your cyber. All of those will typically have a defense cost component as well, but oftentimes they'll be treated very differently. Defense costs will erode the indemnity limits typically. You may have a significant retention, self-insured retention, where you, the company, are going to go out. You're going to appoint your defense counsel in most cases. You're going to control the defense at least until that self-insured retention erodes, with keeping the insurance company advised every step of the way. But those are generally speaking the two buckets, and those are generally speaking the types of policies you're going to look to for your defense cost coverage.
So comparing the two duties, the duty to defend and duty to indemnify, the duty to indemnify is the insurance company's duty to pay covered settlements or judgments that are actually covered by the policy. The duty to defend comes when there's something potentially covered, making it necessarily broader than the duty to indemnify. What does that mean in practice? A claim doesn't need to be well pleaded. It doesn't need to be factually strong. As long as if the plaintiff were to win, that claim would be potentially covered. The duty to defend is going to arise.
And, the duty to indemnity, really that needs to be decided after the underlying liability issues are decided. And there may be times where there is overlap between the issues extant in the underlying litigation and the coverage issues. I'll give you an example. We represent a very prominent Catholic diocese where they have a number of sexual abuse claims. And the insurance companies were raising defenses and wanted to deny claims, saying that the policyholder expected or intended that liability to occur, and therefore we're not going to pay because there's an exclusion or because it's not an occurrence. Take your pick. So the insurance company is basically making the same arguments as the underlying plaintiffs. You knew about this abuse. You did not stop it, and therefore you're not covered. And they wanted to prove that in court while the underlying cases were ongoing. And we said, no, you can't do that. That's prejudicial to our client. Yes, we're in litigation on the coverage issues, but court, please stay, right? Don't let them make these arguments now while the underlying case is still pending, because if they're successful, that's going to prejudice the client in the underlying case. And we were successful in getting that stay in that situation. So how do we trigger the duty to defend? Courts generally go out of their way to find a duty to defend. And the standard is typically, reading the complaint, reading the four corners of the complaint, and comparing those allegations, whether they're truthful or false or even fraudulent, comparing those allegations to the four corners of the policy. If there is any reasonable possibility of coverage, then typically there is a duty to defend. And again, the courts will construe complaints fairly broadly to find a duty to defend. So, they're not going to be hung up on exactly how a cause of action is styled, right? The way they name the cause of action is really meaningless. If the gravamen is some type of negligence, or even if negligence might be implied from the allegations, they'll typically find a way to say, yes, these allegations could give rise to a covered claim, and therefore you have to defend the action. Then the question becomes, well, what if the allegations of the complaint are not sufficient to find a possibility of coverage, but there are facts outside the complaint that would bring the claim within coverage, right? That's extrinsic evidence. It's evidence that is outside of the complaint. It's not alleged, but no one really disputes it, and if it was proven, it would bring the claim within coverage. And courts generally say, yes, in that situation, we're going to anything that's reasonably known or could be known to the insurance company, we'll take that into consideration and try to find and hold that there is, in fact, a duty to defend. Well, what about the reverse situation, right? Can a court or insurance company rely on extrinsic evidence to find that there is no duty to defend? And in most states, the answer is no. New York is very plain about this. There's a seminal case from the New York Court of Appeals that say, no, you can't do that. New Jersey, though, is a bit more nuanced, right? It's going to allow consideration of extrinsic facts to negate a duty to defend where the underlying case would not develop those facts, right? And so here's a couple of examples from actual cases in New Jersey, where you had in one case a complaint alleged that there was a car accident and that the vehicle involved in the accident was in fact the vehicle insured on the insurance policy, but in fact it was a different vehicle that was involved, one that was not insured under the insurance policy. So in that case, the court said, yes, you can look at that extrinsic evidence, and if we consider it, then there would be no coverage, plainly. Another one involved, I think it was a workers' comp accident, where the complaint alleged that the accident occurred on a certain date. And in order to trigger coverage under that policy, you would have to show that the injury occurred during the policy period, when in fact, in reality, the accident happened after the expiration of that policy period. So New Jersey says, yes, you can consider that information outside of the complaint because those issues may not come up in the underlying case. And if it turns out that, in this situation, the insurance company originally, what they should do is, of course, accept the defense, right? Because as pleaded, the claim comes within the coverage. Then they could do their investigation and they can determine if these extrinsic facts negate the coverage. And if that occurs, then New Jersey courts have permitted the insurance companies to withdraw from the defense, but only if the insurance company promptly reserved its rights to do so before then. So you have to check very carefully. Most insurance companies are pretty good about it. They typically will reserve rights pretty early on in the case to say if there's any facts that are change the situation, and they may have to be somewhat specific about it. But generally speaking, if they do reserve their rights and the extrinsic evidence later comes out that takes the claim outside of coverage, they will allow them to withdraw. It is a limited rule. New Jersey does apply it. And, when I step back and look at this, I think, how does this square with general rules of construction? Things like ambiguities have to be construed in favor of coverage. You have to construe exclusions very narrowly. You have to read complaints broadly to the extent any possible coverage exists. You have to defend the entire case. And really, I think all of those principles run counter to this rule, but it is a rule in New Jersey, and you need to be aware of it. But it is limited. So, if you have a complaint that comes in and the allegations within the four corners show coverage, and if to the extent there is a coverage issue, the facts in that underlying case will decide it, then the argument is you can't resort to extrinsic evidence in that case. You have to let the underlying case play out, let the facts come in, and then we'll determine whether or not there's a duty to indemnify.
So once that duty is triggered, what is the scope? In New Jersey, it's slightly narrower than the sister states around New Jersey. New York covers the entire action. So New York won't allow an insurance company to parse claim by claim when a complaint is brought. If any allegation in the complaint is sufficient to trigger the policy, the insurance company has a duty to defend the entire action. New Jersey is a little bit different. The general rule is that the insurance company only has to defend claims that it would have to ultimately indemnify if the claim was successful. There's an exception in New Jersey under the SL Industries case that when you can't apportion defense costs, the insurance company must assume the cost of the entire defense. The New Jersey Supreme Court has clarified after there was a few appellate division cases going back and forth, and a few Supreme Court cases actually trying to deal with the issue as well. They ultimately clarified that the presumption should be in favor of apportionment. That even if you can't, with scientific certainty, split up costs, that the insurance company's duty to defend under New Jersey law would only be for claims that it would ultimately need to indemnify. If you're the policyholder in that situation, what do you try to do to get defense? You argue that it can't be apportioned, right? So, especially in pre-litigation, if there's multiple causes of action being alleged for the same circumstance of facts, you may make the argument that, for example, all of the defense counsel's work in getting ready for the defense can't be apportioned between causes of action when you're taking depositions of the same fact witnesses and you're preparing for the same arguments later.
So let's talk a bit about, allocating defense costs for long-tail claims. And, long-tail claims, we're talking about, asbestos liabilities, environmental, even sexual abuse, where the injury-causing events occur over a number of years, a long period of time, and often many years prior. And the insurance companies will typically argue, well, we have 10 years of coverage that is triggered here, potentially by this liability. We need to apportion the loss over those 10 years. And there are various arguments on either side as to when or that may or may not be appropriate, depending on the policy language and your jurisdiction. But even where pro rata allocation is ordered, right, meaning, yes, we are going to apportion this loss over the 10-year period, the question remains, you should do that for liability, but what about defense costs? Are you also entitled to apportion defense costs over the 10-year period, potentially between 10 different insurance companies? And New York says not automatically, right? What New York says is really the insurance company should pay, an insurance company should pay 100% of it, and then seek after the fact or even during, they can then go out and start an action and seek apportionment from the other insurance companies. the policyholder should not be burdened with that, essentially. New Jersey, on the other hand, does say it's basically automatic. Where there's pro rata allocation, they're going to require not just that the indemnity be apportioned over the 10 years, but also the defense costs. And it's kind of interesting because New Jersey, you often see pro rata by policy limits. So, simple example, you have 10 years of coverage, $1 million each year. Each insurance company would typically be responsible for 10% of the limit in that case because of the policy limits for indemnity. Defense costs, though, at least under a CGL, would be outside of limits. So how do you prorate a potentially limitless defense obligation in each year? And that math is virtually impossible to do. And New Jersey kind of recognized that, it doesn't really make a lot of sense, but we're just going to do it the same way we do it for indemnity because it's a practical solution to the problem and we don't have a better idea. So that's what ends up happening. In that hypothetical, they would apportion 10% of the defense costs to each insurance company, even though each insurance company's primary obligation is limitless when it comes to defense.
So at a high level, what's the difference of your coverage when you cross the state border and go into the sister state? In both New York and New Jersey, there's a defense of claims that are potentially covered, even if those claims are factually or legally weak. As long as a claim is potentially covered by the insurance policy, the insurance company has a duty to defend it. New York requires defense of all claims and allegations within a complaint, where there's any one allegation in that complaint that would trigger the duty to defend. New Jersey, in most cases, does not. New York does not allow extrinsic evidence at all to negate the duty to defend. As Dennis discussed with an example of the case of whether or not the vehicle was covered by the automobile policy, New Jersey sometimes, in those certain circumstances, will allow it when those ultimate facts may or may not be discovered in the actual liability action. And then as Dennis just discussed, for long-tail claims, New York permits insurance companies to seek contribution from other insurance companies. New Jersey requires allocation of defense costs across them.
So when can the insurance company stop defending, right? And where we see this come up oftentimes is where you have an occurrence, and the occurrence results in numerous lawsuits, right? Let's just say your company is building a power plant and has an explosion in the power plant, and now you have, scores of people who are injured suing your company. The insurance company, the primary insurance company, steps up. They are defending, and they have $1 million indemnity limit and a unlimited defense cost obligation because defense costs are outside of limits. The insurance company's obvious goal and incentive is, let me pick off 2 or 3 of these claims. I'm going to settle them for good faith amounts, and then I'm going to be exhausted, and now it's the umbrella insurer's problem to defend these cases, and hopefully you have defense in your umbrella and excess layers. So that's kind of sets the stage for when this problem typically arises. And the law is generally that the duty to defend will terminate when either all potentially covered claims are exhausted and are resolved, and the policyholder gets a release for all of them, right? That's a perfect world, and we're fine with that. Or they could exhaust if the indemnity limits are paid out in good faith settlements, depending on your policy language, right? Where the policy doesn't explicitly say our defense cost obligation is done once we pay our indemnity limit, then most courts say no. Even if you pay your indemnity limit, even if it's in a good faith settlement, we're going to parse the duty to defend from the duty to indemnify, and we're going to require you to continue to defend. So in those cases, it's somewhat easier. Where, however, and obviously most CGL insurance companies got wise to this, and they now most include the language that says our duty to defend terminates once we exhaust our indemnity. There is still going to be a good faith component to that exhaustion, right? You can't just dump and run and leave the policyholder in the lurch necessarily if, they're trying to pay out a claim that's probably worth $50,000 and they want to pay $1 million on it, because they know that their defense costs are going to be far exceed that. So there is still a good faith component, but generally speaking, it is permissible. Most jurisdictions will even have some regulations as to what the insurance company needs to do if that occurs. So if they're going to pay their indemnity limits in good faith, they then have to notify the policyholder that they're doing so. They have to offer to continue to defend. The policyholder would have to reimburse those defense costs, but they have to continue to offer to leave that same defense counsel in place, pay defense counsel subject to reimbursement by the policyholder, or they have to tell the policyholder, you have to get your own counsel, and we'll ensure a smooth transition to the new counsel. So states you're somewhat protective about this, but insurance companies have gotten wise and seem to have included the language they need to include to get out of the defense in certain situations.
So the duty to defend versus the duty to reimburse can arise first under what the policy calls for. So the CGL policy is going to have the typical duty to defend. The insurance company controls the defense, appoints defense counsel. Policyholder can sit back and kind of use the protection that it's promised by the insurance company. Other policies like D&O and E&O typically provide that the policyholder themselves will go seek counsel and then submit invoices to the insurance company for reimbursement. What does that mean practically for the policyholder in terms of when their protection is triggered? Very little. So unless clearly stated by the policy, the duty to reimburse is going to be triggered under the same circumstances as the duty to defend. There's also circumstances where what would start as a duty to defend may turn into a duty to reimburse. So courts across jurisdictions have recognized the tripartite relationship between the insurance companies, policyholders, and defense counsel. The defense counsel obviously is paid for and hired by the insurance company, and they have an ethical obligation to their client, the policyholder, to protect them. There are various circumstances where that may cause a conflict, where the policyholder, it may be in the best interest of the policyholder to seek their own defense counsel and then submit invoices for reimbursement. One example may be where there's multiple causes of action, a cause of action involving fraud where that would negate coverage, and defense counsel is going to have split interest in that situation. Generally, insurance companies must reimburse all defense costs in a mixed action. So in New York, even over express language, where allocation can't be reasonably made, it's going to be subject to later recoupment after liability is determined. So,
Chad, a little bit more on the right to independent counsel. Sal did hit on this a bit already. Here the typical situation arises under a CGL. You've got defense costs outside limits. The insurance company comes in, they appoint, their panel counsel, and they can control the defense. What do I mean by panel counsel? Insurance companies have a list of insurance defense counsel. They receive favorable rates from those defense counsel in the promise for a volume of cases, right? So these attorneys are typically working for, a bit less than what the market might otherwise dictate, because they're getting more and more cases to defend from the insurance company. And so there's that relationship there between the insurance company and the counsel, but the insurance company is appointing that counsel for the policyholder. The client is technically the policyholder. The duty of loyalty is technically to the policyholder, but there's always that incentive, right? There's something in the background there. There's a bit of a smell to it, right? That defense counsel is going to want to keep the insurance company happy because they know they're kind of beholden to the insurance company for the next matter. So there is that tension. States recognize this as the tripartite relationship. New Jersey calls it the triadic relationship. And there is that conflict, and in some cases this works out, in many cases I should say, this works out just fine, right? The claim comes in, defense counsel is competent, they're able to defend the claim adequately, and there's no real concern about, is defense counsel going to steer the facts toward uncovered claims? Maybe there's an allegation that there's both intentional and negligent conduct. The concern would be defense counsel steers the case toward the intentional conduct, which would then be excluded, and it keeps the insurance company happy, right? There's a number of different potential conflict situations. There might be strategic differences. Policyholder wants to settle the case, and they may want to pay a premium to settle early to avoid reputational damage. There could be co-defendants with divergent interests. That happens a lot in additional insured situations where they're insured under the same policy, but they have divergent interests. It's pretty clear they need separate counsel in that situation. So there are circumstances that will give rise to this conflict, and where the conflict exists, the policyholder has the right to say, no, we appreciate your offer of your panel counsel. However, because there's this conflict, we're going to go with a counsel of our choosing, and we're going to kindly send you the bill. And a lot of times that works out just fine. More often than not, the defense counsel chosen by the policyholder is more expensive than the panel counsel. They don't have the same favorable rate. So you get into a dispute about what's usual and customary. You're going to look at the jurisdiction. A defense counsel in New York City is going to be more than, some small city in Arkansas. You're going to look at the complexity of the claim. And that's typically a negotiation. Sometimes it requires litigation, but that's typically a negotiation. Let's see, we're on our last slide. Give us one more minute.
So
26 seconds.
Fine. I will try to get it done.
And I will note that the other group went over by at least a minute.
So what is the policyholder's remedy when the insurance company breaches their duty to defend, when they refuse to give the protection that the policyholder was promised? First is compensatory damages of the actual out-of-pocket defense costs. There's prejudgment interest. And then states have different mechanisms for doing this. When a policyholder is forced into a defensive position against its own insurance company, by New Jersey, you're allowed to collect attorney's fees for your coverage action by court rule. And in New York, there's a case, Mighty Midgets and its progeny, that allows pretty much the same result.
Okay. So thanks for your attention. We'll be around if there are any questions.